fact of the murder wouldn't get it as an overt act that is a part of RICO. So I understand you need to do a little bit more than that.
She's one of the two young ladies who lured Mr. Holmes and his three friends back to the location, to the location.
It sounds like him and Blaylock set up this kid with girls, which is a sad thing that happens a lot. But I have a question. Is any of this related to YSL? They're saying there was postings of YSL after the murder, but me as a person with common sense, I doubt Thug was like, yo, go kill this 15-year-old kid. The RICO charge and all this bullshit is just kind of fucked up. It's like everyone syncs together, even if someone committed a crime and it wasn't even related to each other.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head, that is the victim that it was his homicide that he was investigating, that he was shot in the head, whether or not he was present during the autopsy or not, and whether or not
Do you think that there's any chance he was present during the autopsy?
Sometimes they are.
That seems not true. I don't think I've ever heard of a detective being present during an autopsy.
Was he present at the scene before the body was removed?
Yes, Your Honor, I believe so.
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Grady in ambulance 571. He was pronounced dead at Grady at 6:10.
If he was at the scene, he wouldn't have seen the victim at the scene, so that wouldn't be helpful with regard to these photos.
Correct.
And Your Honor, we were trying to avoid the ME, so if we can have some stipulations to that, or we can have the ME come in for
Why don't y'all get together? I'm going to hand these back for now. And
Lil Rod's lawyer right here and the state need to have a little meeting about who's going to come in and what's admissible and all that nonsense.
The state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-803.
Doesn't want the jury to know about the guilty verdict.
The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment judgment against other persons other than the accused.
What's the state's plan with regard to that?
As to the conviction itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea, so it's not a statement that we argue are admissible against all of the defendants in this case. The facts that are presented, that the jury takes as evidence, are admissible against all of the defendants, including any postings or statements that Mr. Ryan and Mr. Blaylock made as a result of or in furtherance of that act.
Trying to sort out the nested hearsay in one of the wiretap conversations.
Your Honor,
yes.
Before we turn the page, can I just get some clarity because I'm confused. The state, I believe, indicated that they thought the facts of the murder case involving Mr. Ryan were admissible in this trial, but the conviction wasn't. But then they started talking about limiting instructions. And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
We are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce that conviction should be considered against Mr. Ryan only. But the facts of the murder and what happened should be considered as evidence that they choose to, believe it against anyone currently on trial.
Be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy. And that would be admissible against everybody charged with the RICO count.
We would be introducing the evidence that Mr. Ryan and Mr. Blaylock did it and what connection we believe it has to YSL.
I'm really interested in the YSL connection.
It did to promote YSL before, during, and or after.
Right. Is that clarified?
Well, it clarified that we do not have an agreement, and I'm diametrically opposed to what the state is saying.
Matt Sharp's funny as shit.
That verdict was not the verdict of fact finders in this case, which we chose, and our jury. I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment. It's on appeal.
All right.
The conviction. I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overt act, which as an element
to Mr. Ryan.
Well,
is what they're saying.
Well, no, they just said it against everyone as far as count one to RICO.
The facts that they're going to present, not the conviction.
Okay, well, I don't as I understood the case law as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
It just seems a bit unfair.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO.
They're going to use it against Mr. Ryan, but the jury's, this is a YSL trial.
By Mr. Ryan. This is not a plea of
No,
guilty.
he was found guilty. It's still a judgment of conviction.
Well, it's not a final
And
judgment. It's not appeal.
pendency of appeal doesn't matter in terms of admissibility.
I don't believe that if Mr. Ryan is charged with a RICO count along with my client, the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury finding of a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights.
Well, we're going to have to get that sorted out fairly quickly if we think that within the next 2 weeks we're going to get to this.
This trial's so voluminous that it's like every 2 or 3 weeks, there has to be multiple meetings to figure out evidence.
If they're going to be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses.
Arguing about intrinsic acts.
It also is a part of is the YSL gang itself and conspiracy that the gang itself makes 5 YSL members and 2 others, stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself, serving, protecting, and enhancing the reputation, power, etc. of the enterprise of acts that include assault and threats of violence.
60% of you aren't subscribed. Please hit subscribe to ease my pain of listening to Miss Love yap all day, and hit the notification bell.
Circle the wagons around YSL members show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. There are people who perform acts during the course of his trial. At least one person that we believe were intended to intimidate a witness who was actually on stand at the time. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they are going to come to their defense of the act itself.
We'll hear all of this argument. Right under 404B, I'm waiting to hear which of these 3 categories it falls into. We're talking about 2 different issues. Which of the 3, and then 404B.
It is not 404B. It is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to.
Right. Ryan and the other YSL members in concert in stabbing Mr. Bussey. Our position is that this conspiracy didn't stop at the jailhouse doors. It's necessary that the jury sees that it is ongoing to show to them the truth and the whole truth that we believe our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Ebinger, Mr. Myrick, and Mr. McMullen are seen in the photo that I don't know that the court needs to see it, but if it does, we can present it on the Zoom camera to show the concerted action on their part in stabbing Mr. Bussey.
We're confused now because the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime. And their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find. The gang is continuing. The only thing they need to prove is that by the day of indictment, this happened. It really doesn't matter as far as what the jury needs to know for the state to meet the required elements. It doesn't matter whether the gang is continuing.
But the state can prove, if it chooses,
They sure can.
that it's an ongoing conspiracy.
But that doesn't make it necessary to complete the crime.
Ongoing and continuous conspiracy that is YSL, its enterprise, and the members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. This act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count 1 in terms of what we're alleging that they conspired to do.
So she's trying to get in this prison shanking. I'm not sure if there's enough evidence that actually correlates it to being a YSL situation, because apparently there was more than just YSL members involved.
There's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature.
Well, now we're talking about trying to prove the charges against the defendant based on something not in the indictment.
Well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right, we do. And I think at some point...
Still waiting on that law.
I think at some point, and I might be wrong about this, but a contrary position was presented and...
I mean, it's going to be real fun when we get to the verdict form. All right, so we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately and
I think that
This is the shit show that happens when you try this many people together. And what makes it even funnier is this is only 6 of them when initially there was like 28.
we do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts.
How long is she gonna talk for? Holy fuck. She's been yapping for 13 minutes straight. Not even trolling.
These people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey.
How is it? And you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overt act, in as much as it could be considered an overt act to promote, to support the gang. So in as much as it is or can be considered an overt act for count 1, and that it is gang activity, which it is.
All right, I'm not quite sure where I got this language, but I jotted down, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the indicted offense?
So if the indicted offense is the conspiracy itself, it's an uncharged offense that arises out of the same transaction, a series of transactions as the charged offense of count 1.
Seems like a bit of a reach.
And the series of transactions is the acts of violence that have been described. Overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
They're not connected. That murder is not connected to a random jail stabbing over commissary.
Actions that occur before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have, we leave posting, I'm sorry, we made you a thug, so early little thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I just named are, yes, alleged overt acts. So clearly intrinsic regarding the conspiracy and the gang itself.
Intrinsic acts are actions that occur at the same time and under the same circumstances as a charged crime. The inseparable crimes theory allows evidence of uncharged misconduct to be admitted if it's relevant to the defense motive, if they occur at the same time and under the same circumstances as the crimes charged. It's a jail shanking, dude. Over commissary. What are we doing?
What I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members. Am I understanding you correctly?
Or was just a group of friends that got upset about commissary?
And to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, Fleetwood, had all, I believe all of them had been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident.
Eppinger is an absolute savage. I ain't defending that man.
To the extent that the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL from day one, from openings throughout up to even now. The assertion by every defendant is, even the witnesses, I did it for myself, by myself. Every step of the way, the state is having to rebut that assertion that this is just me, I'm a criminal, but they aren't.
And one of them was a video of somebody smoking pot, wearing a chain, saying some things. BB maybe, and Eppinger.
Mr. Eppinger appears in the Instagram picture, an Instagram video, and BB shows him the chain. But there's another portion of the video in which Mr. BB is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had options to discuss.
A lot of these guys, man, they were self-snitching, posting shit.
This is all acts involving someone that's not sitting here. If we could have a couple minutes just to talk as a group to figure out what our stance is.
Isn't that crazy? Overt acts about people that aren't even in the courtroom. They're just part of YSL.
So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022.
The defense didn't destroy anything. Antonio Sledge destroyed it himself. Of course, the defense lawyer is going to be like, so what you agreed to in your plea is not true because the witness said that.
Demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted.
She just called it perjury.
The fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed, relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28th, 2022. They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So in as much as they are inconsistent and contradictory to the testimony that he gave,
I can see 444Y coming in as a prior inconsistent statement because he definitely testified inconsistently once he was on the stand to what he said in that document, admitted as factually true all of those things that he initially. That's a separate item, and I'll hear argument on. So, do you want to say anything else about that? You say, and it's a prior inconsistent statement, and it's impeaches him by contradiction.
yes, and it corroborates the state's position and.
Well, I know why you want it.
Corroborates the state's position is not a hearsay exception.
Right, I understand.
Both of them just fried her ass, dude.
I just have to address one thing. And,
Okay.
and I'm sorry, I'm not trying to be a one. This is exhausting because every time we are on the same page, in Your Honor, things somehow get relitigated. We were up at the bench. We all talked about this, and we determined what would be admissible as prior inconsistent statements. And the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. Those factual acknowledgments were read into the record, fully litigated. We not only heard from Mr. Sledge, we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. There's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. It would not go back to the jury because it would be continuing witness. We've discussed this, and now we're back to arguing about it again. It was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. Also, it should never go back to the jury to begin with, so I don't even know what purpose it would serve at this point.
No.
So,
Well, the statements on the document say every bit of this is true, and I acknowledge every bit of this. He testified inconsistently to that with regard to the majority of it.
he did, but he never said at the time he didn't acknowledge it to be true.
I think he did.
What the fuck are we wasting so much time on this for?
On the first day of direct examination, he specifically said that one was not true. He said that. On the second day, he came back and said, yes. First day, he said no.
It's interesting that Ms. Love says that because when she actually was examining him, she misspoke and said that he adopted number one. So now she's saying he denied it.
Max Sharp just throwing shade.
The state's not willing to redact it, then it should not come in. The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue.
Mm-hmm.
That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
Max Sharp is a real one. Like, he's always fighting everything. I love it.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the
but
jury in any way hear the factual acknowledgments that he still acknowledged?
I believe that the answer is in some form or fashion they did.
This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to.
On cross-examination. Oh, geez. Oh,
Appreciate it. All right, I'm going to give you.
He just like roller ankle. Damn, bro. Hope the judge is okay.
when he said, when the state put these words in your client's mouth. So the point of it is, when on cross-examination, whether it's effective or not, an entire statement is essentially sort of undermined. You say you didn't understand it, you lied because your mother was not well and you wanted to get out of jail. Validity of the statement itself is now, it's impeached. It's almost like you're impeaching the statement itself. You're saying that the statement isn't. And so in as much as the statement as a whole does allow the jury to understand, it does place the few admissions he makes in context. We ask that it be admitted as not just a prior inconsistent statement, but as impeachment by contradiction.
Your Honor, A, there's no contradiction. He said that the state presented me a form that they wrote, their letterhead, and asked me to initial it, and I did. And that's exactly what the form is. It's a form that they wrote on their letterhead that they asked him to initial, and he did. There's no contradiction. The document doesn't contradict anything he testified to. Reality is, if they're arguing that things are prior inconsistent statements, they've already been played in the video. and we've already heard it.
We've heard so many prior inconsistent statements about Antonio Sledge.
Arguing things aren't inconsistent, then they shouldn't be played. There's no reason for the hearsay to come in. So even if I granted to them that it's a prior inconsistent statement, we've just established that we played a video. That's already been covered by the video.
All right, I'm going to rule on this one that the portions that he disavowed on the stand may come in as extrinsic evidence of the prior inconsistent statement. We'll deal later with whether they actually go out as continuing witness or not. We never read that in, right?
So
I'll
number
remind-
4,
I'll remind
We did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told away from number 4. Told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document that has number 4 in it.
That's so shady. What's the switch up for, eh?
I mean, I don't know what we're doing.
There was an objection to it. We followed the court's instruction. We did not ask him about it. Prejudicial when he is not, he denies it, and we change it. We take it out that he was planning. He had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they
ex-
were planning it.
Judge, that's the point that I'm making. That he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
or that's not
well,
true.
it's true, but I didn't know.
No, he's saying that's not true. He is
No,
saying
he's not. He's saying, I don't know. I think maybe XYZ. That is not coming in.
Miss Love is misrepresenting what Antonio Sledge said. Judge caught it and says it's not coming in.
Well, we can't make it say something.
No,
that
not
doesn't
put the
say.
word no.
We
He
don't know.
said, Mr. Wright said on the stand
Okay.
that is something that we did not agree to, and we took
All
it.
right.
And that's exactly the point. Mr.
Exactly.
Wright said all this stuff on
We're not going to be admitting 460Y.
Thank God. Miss Love just admitted the whole defense's position on this. This has already been said on the stand. Why are we going over it again?
I don't think we should have to litigate this again, and I'm going to explain.
Okay.
The state, under the state's theory, but I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all, and then they take the stand, and then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess, and we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this problem.
Max Sharp fighting.
Even if Mr. Sledge did say there were never any other versions, which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. Given the number of 403 concerns there are with 451 through 456, I'm going to just stand on my ruling excluding them.
Help them to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling, revive the ruling that the court made.
Denied. Let's move on.
Judge wants to move on, denying shit fast.
Segments of those videos that showed Mr. Beebe and Mr. Eppinger referring to they weren't referring to it, but it's clearly involving the armed robbery that they're charged with that's listed as an overt act. I can say on behalf of myself and Mr. Steele, we have objections. I think Mr. Steele was going to articulate them to those segments.
What's going on now? What's up, man?
When Christian Eppinger gets onto the call, he throws up what we had alleged is the YSL sign, and then Durante do it.
Actually, Trenton.
What's up, Slime? All right, Slat.
But they hit him up. They hit on my heart, and they give me, I done built me a business up.
I don't know what he said. Hopefully they say what he said.
Something about what was on the clothing.
We believe that this is clothing that we've seen on other YSL members, OTS on the line clothing. We've seen, I think we have a few other posts, Your Honor, with them wearing similar type of clothing, but it has either YSL related terminology on it. On his, I believe, the headpiece as well as the shirt.
All right, can you show me that last? And what does he say?
Built me a business up.
I heard that part. What does he